Herbert Schlanger is unique among the people who represented themselves at the Supreme Court. He was filing a habeas case against the Air Force without any legal training, and after losing his case, he became a lawyer himself. Schlanger went to high school in the Bronx. While enrolled in the Air Force, he entered a program where he would study mathematics at Arizona State. Then, something went awry. According to the Air Force,
he continued in this program until June 1968, when he was removed from the program by his superior officers for failure to attend classes regularly.
According to Schlanger,
until June of 1968, 10 weeks before my scheduled graduation, at which time I was summarily removed, purportedly for having demonstrated a lack of officer potential by cutting some classes. But in fact, as alleged in my petition, I was removed because of my participation in the formation and leadership of the Arizona State University Civil Rights Board, a group which sought to quiet and adjudicate ethnic and racial grievances arising on campus by working with university and city officials. The removal was unlawful both substantively in that it violated First and Fifth Amendment rights, and procedurally in that it violated regulations and due process requirements of the Fifth Amendment. I really do not believe, sir, that it was a coincidence that following my removal for civil rights activities from Arizona State University, I was assigned to Southern Georgia, with all due respect to the South, sir. I feel that the government felt that any further proceedings would be looked upon more dimly in the Middle District for Georgia than perhaps in the Southern District of New York.
While on leave, he went back to Arizona to finish his degree and file a case against the Air Force. The Supreme Court could consider, was there a valid habeas case? Was Arizona the right venue for it? And what would the recourse be if Schlanger won? Schlanger summarized it like this.
If indeed this court upholds the government's position concerning jurisdiction, the Fifth Circuit and the District Court for Georgia no longer have jurisdiction in the matter since I've been removed and reassigned to Iceland. If, on the other hand, the court holds for my position, contending that the District Court for Arizona does have jurisdiction, then it should properly be remanded to Arizona rather than Georgia, since that was the first filed action, and that is where the cause of action arose.
One justice complimented Schlanger on his professionalism.
What test, what limits would you put on it? Would you just leave it in the discretion of the district judge?
I would say, sir, that broadly, for those people contesting their induction, let's say, which I am not, this is an enlistment, but their induction as conscientious objectors, for instance, much of their evidence to prove their claims might in fact be where their local draft board is. If a person's inducted in New York City and then sent to Fort Benning, Georgia, the Army may hold a hearing, and it may just be perfunctory, as has happened in several cases.
So you say he should at least be able to file his habeas corpus action in the place where he lived when he was inducted, is that it?
Yes, sir, because that is the district with the most significant impact on the facts of the case.
Well, then would you confine it to the district with the most significant impacts on the case?
I'm searching for some way to simply say I would like to be fair and equitable.
I don't mean to be.
Yes, sir.
I was examining it, but undoubtedly you've thought a great deal more about this case than we have so far, and
yes, sir. Well, I've been grappling with the same question.
But the justices remained puzzled what he expected to get out of the case.
Further questions?
May I ask you exactly
Yes, sir.
what it is you're after?
At this point, sir, I would like to be discharged from the Air Force. I cannot see that even if the Air Force commissioned me, I could make it a career successfully after the publicity that has been attendant to the case. And very truthfully, since my initiation of the proceedings, I've discovered that I have hopefully some aptitude for the law and would like to make the law a career.
The Air Force's lawyer was also perplexed by the case.
I think I may safely say that there has never been a serviceman case like this one in the history of the writ or its analogs.
And he argued that Schlanger had no case in Arizona.
It is true that Sergeant Schlanger was physically within the jurisdiction of the Arizona court on the day he filed his petition, but in our view, he was not in custody there, and there was no one in Arizona having jurisdiction over him, and he did not allege that there was.
the Supreme Court returned a decisive 8-1 that the case could not be brought in Arizona. Schlanger reapplied in D.C., as discussed during the trial.
I was transferred to Iceland on the 5th of January.
Let's assume you were physically now in Iceland.
Yes, sir.
And wanted to bring this kind of a habeas corpus action. Where, under your theory, could you bring it?
I believe, unfortunately, Your Honor, that I could only bring it in the District of Columbia.
Only there, because that's where the Secretary of the Air Force is?
Well, apparently, Your Honor, that it's been held by this court, never directly, but at least implicitly, that the District Court for the District of Columbia has jurisdiction over American citizens outside any other district courts.
Before that case reached the Court of Appeals, he was discharged in 1972. The case was declared moot, and the Supreme Court did not invite him back to argue the case. Schlanger went to law school, got admitted to the Arizona bar, and brought a new case which reached the Court of Appeals in 1978, but was dismissed again. By 1980, Schlanger established a law office in Atlanta, Georgia. A quick disclaimer, a lawyer handles many cases in their career. For this project, I can only rely on the few newspapers and archives that I could find with a Google search. In 1985, he represented a widow against the Florida bar over withheld interest. He also handled a case about ownership of a travel agency, which would end with a frivolous lawsuit claim in 1993. Starting in 1989, Schlanger represented multiple businesses against Florida counties, which had set aside government contracts for minority-owned businesses. Schlanger's main argument was for equal protection under the 14th Amendment and awarding contracts on merit without consideration of race. In 1990, the U.S. Supreme Court declined to hear his Hillsborough County case, and in 1991, they declined his Broward County case. In 1993, the U.S. Supreme Court decided Associated General Contractors of America v. Jacksonville, Florida, rewriting the standards for setting up equal opportunity contracts and for challenging them. That decision was similar to a Hillsborough County case that Schlanger was arguing at the time in the Court of Appeals, so it was dismissed. In 1996, the Miami Times reported a moratorium on contracts while handling further challenges from Schlanger's clients. These years of lawsuits made me think back to Schlanger's college experience.
As alleged in my petition, I was removed because of my participation in the formation and leadership of the Arizona State University Civil Rights Board.
There are people who could talk about this more eloquently, but I'm reading all of this as a particular takeaway from equal protection and the 1960s civil rights movement. And that view isn't all that different from the Supreme Court's rulings in the 1993 case and in more recent affirmative action cases. In 2000, the Internet Archive captured a snapshot of a website for Schlanger's law office. In 2006, he won an appeal for a client in a DUI case. In 2008, his own DUI case was in appeals court. Schlanger would later represent himself in a successful appeal in 2009. The most recent online mentions of Herbert Schlanger were cases in 2016 and 2018, where he represented 2 adult clubs which had paid tipped employees a lower minimum wage. This is a complex career journey with unexpected turns. I could not really put this guy in one box. Wherever you stand on politics, I do wish that he got another chance to argue in front of the Supreme Court, this time as a lawyer. If you want to hear more episodes about people representing themselves at the Supreme Court, please like and subscribe. United States Supreme Court rules and practices have changed since these cases. This was a podcast episode, not legal advice.